hit somebody in the crosswalk. Just had a pedestrian in the crosswalk gets hit. When the accident occurred, Donald was driving west and the other guy was crossing in front of him. And then you have the plaintiff offers various witnesses who saw the thing, who saw the accident, to prove that the defendant was at fault. On what basis would you object to the admissibility? So it just gives you an opportunity to do everything. That car is running that red light, and he's gonna hit Peter. Very straightforward. We know what the answer should be. So, just to look at some various. Okay. I want to get it, sit it on there.
This is the good one or the bad one? Is this the good one or the bad one?
This is the bad. This one is, this is just one random one I picked up. I would object to the statement as hearsay, but it would be admissible under the exception of present sense impression. When the defendant is perceiving the event as it happens and no time elapses from the statement being made regarding the event that is present sense impression.
Ooh.
Here the man made the statement as the event was occurring and he was perceiving it. Out of these, I don't know how much each question was, but I think they were 4 points each.
They get you 1 point. That is 1 point.
Did you give it 1 point?
Okay, I mean, what would you give?
That is 1 point.
Okay, I'll give it
Because they,
Okay, what's the problem? Let's hear from some people, what's the problem?
They spotted the real, well,
The problem?
they spotted the real.
there's no analysis.
She just gave the law, but she didn't give you anything.
Is that really the law?
She didn't give the law.
And then
No
it's
time
perceiving
elapsed.
the event as it happens, no time elapses from the statement being made regarding the event, So is that even the right word? It's supposed to describe or explain the event. Now, a lot of people always ask, well, do I need to know the rule verbatim? I'm not requiring you to know the rule verbatim, but at the end of the day, you got, each phrase is another element. So if you miss some phrases, you missed the issue. I mean, you're missing an issue in there if you don't know what those little phrases are. So you can't have that. And so, of course, then it goes on to say, regarding it as, that's supposed to be the rule, and this is the analysis and the conclusion. Here the man made the statement as the event was occurring, and he was perceiving it. So I'm assuming that means that even though it is hearsay, that the statement is gonna be admissible.
There's no conclusion.
Right, it doesn't conclude. So then we have Dan ran the red light. Peter's attorney also offers the written and notarized statement from Allen. It states Donald ran a red light. I object to the statement as hearsay, and it would more than likely be sustained. Hearsay is a statement made by someone other than the declarant to prove the matter asserted. Here the statement is being offered as proof that Donald ran the red light.
Damn.
Do we know, is there any particular issue?
Oh, I didn't really get the whole rule right.
Kathy testifies that she heard a man standing at the intersection yell at Donald, "Stop, man, stop. That light's red, man." I would object to the statement as hearsay. However, it will be overruled because it is considered non-hearsay when the receiver is receiving knowledge or notice. Here, the testimony is offered as such to show that Donald received notice from a man about hitting Peter. What do you think about that?
The wrong issue.
I thought it was wrong.
Do we know the issue?
Excited.
They say
Stop, man, stop.
She heard.
Yeah, excited. I would say excited utterance.
What would you write?
I issue spotted excited utterance.
And one other thing that I also wanted to show, just like in that last one, that person studied, how people talk about all the time, I studied, but I don't know why, like, man, I studied, and I can't get no better grade. And I just showed you one when I said they just wrote rules, but I don't even have the exam, because I don't think these go with that particular, no, this is either 8 or 9. And this, I said, I like the bold, no analysis, good memory of rules, very good, problem with issues. Set out the rules, no rules, can't keep doing the same thing. Now, this right here was a student, and this was probably a D, who memorized all the law, but there were problems spotting issues. Because 3 components to exam study, you have to spot issues. You gotta read a lot of hypos and questions and old exams to learn how to spot issues. You have to study the rules and the law, and you have to practice writing your answers. And you have some people doing different things. You have some people that they're just reading the code, just feeling like, well, if I know this rules, I can write some real law in the exam. You wrote the real law, and I'm sure that person passed the class, because it'll be close enough to everybody else to at least fall at the bottom of the bell curve. But it's just not gonna make it on the bar exam. It's not gonna make it.
So with that question that we just did, was it an excited utterance?
No. Okay, so let's compare some of the answers to the good answer. The student who made only 1 B the whole time in law school. All the rest A's. I know I didn't make all A's, far from. I don't know how to close it down quick. And both of these students did very well. Drake Lewis 3.8, 212. I told him I was gonna tell y'all who they were. That's 10. That's the wrong year. Okay. And like I said, I had my answer, but it was pretty much basically the same thing that he was writing. But and then did you send yours? You email yours? Are you really going to? I'm just saying,
I emailed you, but
Okay, so let's take a look at his number one. This was for, and I actually wrote both of them in mine. Defense made object to Allen's statement claiming it is inadmissible hearsay. A statement is hearsay if the defendant originally made it out of court and is offered at the current trial to prove the truth of the matter asserted. Ordinarily, hearsay is not admissible. However, a statement, although hearsay may be admissible, it fits within a codified exception or exemption. One such exception is the excited utterance. To fit within the exception, the statement must be related. Oh, y'all not seeing it?
No, I was confused.
At least it wasn't 2 hours of me doing that. I did one time. I had some high school students in there, and they let me talk for 2 hours. See? Okay. One such that excited utterance. To fit within the exception, the statement must be related to a starting event or condition made while the declarant is still under the stress of excitement caused by the event or condition. Here, the statement that the car is running the red light was offered to prove what it asserts, i.e., that the car was running the red light. It was made out of court because it was made at the scene of the event, hence its hearsay. The declarant was under the stress of the starting event of watching a car run through a red light as evidenced by Allen screaming him as excited. The statement was related to the same event as if described the cars running through the light. Hence, the statement fits within the excited utterance exception and is not barred by the hearsay rule. Defense objection should be overruled. Now, you think he should get his 4 points?
Yes.
Okay. Now, what you wrote, how many points would you give yourself? Oh, you can write it. Okay, so let's look at number 2. What would you give yourself for your answer?
Me?
Yes.
Oh, not before. I probably
Why not?
2.5.
Why?
Because compared to his, I don't think I could. I didn't do my. I didn't do my.
You
analysis.
emailed it, right?
Yes, I didn't
Okay.
do my analysis on that.
Okay, but I'm gonna take a few and I'll take a look at yours. Okay, let's move down here to C. Stop, man, stop. That light's red, man. So we have C. In this with hearsay, statements hearsay, the original made out of court, offered to prove to the matter asserts. Ordinarily, hearsay is admissible, however, statement, although hearsay may be admissible, fits within a codified exception. One is the presence and impression. To fit within the exception, the statement must describe or explain the condition and must be made while the declarant is receiving the condition or immediately thereafter. A statement is or written assertion or nonverbal conduct intended as an assertion. In this case, the first part of the statement, stop man stop, is a command and not offered in the current trial to prove what it asserts because it doesn't assert anything. Hence, the hearsay rule does not affect its admissibility. The second part of the statement, the light is red, man, is offered to prove what it asserts, i.e. that the light was red. It was originally made out of court as it was made at the time of the event, hence the statement is hearsay. The statement describes the condition of the light being red. It was also made while the declarant was perceiving that the light was red. Hence, it fits within the presence and impression exception. Now, what do we notice about the answer?
Broken down.
All of the elements you have to really address all these elements. That's why you have to know the law and you have to be able to use it. Okay, you have to be able to use it and show. You don't just say that wasn't hearsay because he was looking at the light when he saw it. That's not an answer. Yes, ma'am.
One question, like at the top of each of his answers, he explains hearsay each time. Do you want us to do that too?
You don't have to give the rule, but a good answer really does say that why it is hearsay. I mean, that you don't have to, we know as far as the rule is concerned, y'all just copy and paste that anyway.
Right.
But as far as the analysis of it, to say that in this case it's hearsay because it is being offered to prove what it asserts, it's just like one sentence. It's really just one sentence because it's being offered to prove what it asserts, which is that the light's red when he went through it. And so therefore it's inadmissible unless it fits within a delineated exception or exemption to the hearsay rule. We know why we're talking about exemptions because the non-hearsay are exemptions to the rule, right? So that's where we are with that. Then we have D. Diane heard another man standing here ask her, did you see that car run the light? What you have for that? Let's see what Bob wrote. What Bob is, I don't know. I'm not saying who this is, I don't know who this is. But this is, what would you write? We have unique comparison.
Yeah, narrative.
So this one, D wrote, I would object to hearsay and the court will probably sustain. Hearsay is an out-of-court statement made by the declarant who is not at trial to testify to prove the matter asserted. Here the statement is offered only to prove the matter asserted, and the witness can only testify to the question and not what she saw herself. Does that sound like anything that we've been talking about this semester? D. Let's see what somebody else wrote.
If I have to beat that, I think I'll be good.
A question is not a hearsay statement if it is non-assertive conduct. Is this D? Non-assertive conduct is admissible under the non-hearsay exception because it does not intend to communicate information or fact. Therefore, the statement is admissible as non-hearsay. What y'all think about that answer? How much would you give for that?
Zero.
They must have read the wrong one.
No, that was what they were meant to write about.
Oh.
That is zero.
Non-assertive conduct. You see how this feels? Like really, this is over your holiday. You gotta read this, and you know that you did not say this. You know you did not say this. Conduct.
What you like to drink over your
You don't want to know. You say, you know what? I'll do it later. I can't right now. This gonna mess up this Christmas movie that I'm watching. Okay, yeah, whatever. This morning they were playing The Dog Saves Christmas. We go back and watch the rest of Dog Saves Christmas. Okay, so the defense may object to the admission of the statement claiming it's hearsay or narrative is not admissible. However, hearsay only affects the admissibility of statements. A statement is an oral written assertion or nonverbal conduct intended as an assertion. Here the communication, did you see that car run the red light, is a question and does not assert anything. Hence, it is not a statement within the meaning of the hearsay rule and is thus not barred by it. That's what you supposed to have on your paper.
Wait,
Can,
Wait, what?
can you switch it?
Oh,
That's
okay.
right.
You have to what?
I have to read, yeah.
Oh, okay, well, I'm
Yeah.
sorry, I won't put that one back up, I'll just read the bad, I'll read the bad answer. Okay, so here, ordinarily, hearsay is not admissible. However, hearsay only affects the admissibility of statements. A statement is an oral or written assertion or nonverbal conduct intended as an assertion. Here, the communication. Now, what part is that? That's analysis. Here, the communication. Did you see that car run the red light? And I'll note in quotation marks, is a question and does not assert anything. Hence, it is not a statement within the meaning of the hearsay rule and is thus not barred by it. Defense objection should be overruled. That's it. George is crossing the street in the same direction as Donald, but is colorblind and uses a seeing eye dog to help him traverse along the streets. He testifies that just as Donald approached the intersection, his dog stood on his hind legs and barked, signaling that the light was red and that he should not cross. Okay, what's the issue here?
The clearance is in person.
What is it?
I would say effect of the hearing, like effect on the hearing.
What do you mean?
Well, whatever the dog did to alert him, I guess could be used to argue that.
That's what your answer would entail.
I mean, I guess.
I know you haven't fully
I
studied.
had absolutely no idea how to get that one.
Okay, anyone else?
Clearance is a dog.
Okay, okay, okay. Anybody else? And that's why, you all do really have to practice writing the answers so that you can become accustomed to writing them out. Because I can tell you, when I start writing answers, I have to really back it up a lot. Because I don't write them out a lot, and so I have to practice doing that. They would object to admission of the statement claiming the dog's nonverbal conduct was hearsay. Ordinarily, a statement is that the hearsay is not admissible. However, hearsay only affects the admissibility of statements. A statement is an oral or written assertion or nonverbal conduct intended as an assertion. Louisiana courts have held that nonverbal conduct does not qualify as a statement within the meaning of the code, as animals are not capable of discerning the truth. Here, the dog engaged in nonverbal conduct that its owner interpreted as an assertion not to cross the street. However, since the nonverbal conduct was performed by an animal, it is not a statement within the meaning of the law. The hearsay rule does not apply. Remember, we had a couple with the dog eats on my the YouTube video. Yes, ma'am.
This is like real random. But I have a question. If this conduct is not acceptable or is not admissible, then how come you have like dogs that search cars and they do all of this? So by
Same
barking, so that's not admissible?
It is admissible. But we're saying that this is not inadmissible
Oh, okay.
because it's
It's not in
it is an assertion. They are asserting something. Yeah, he is the dog asserts that there's drugs right there. I used to have a case in there, but it was a case from Massachusetts or somewhere where they kind of acknowledged that, but we don't do that. That's why I took it out to confuse people. We don't accept assertions of animals because the animal, the whole purpose of cross-examination is because you're saying, when you look at the protections, you're saying that you might be lying, but the dog is not going to be lying, and we know that we can't cross-examine him even if he was. So we don't even recognize that a dog can have hearsay. I mean, that he can make a statement and all that, And so for that reason, I don't like to confuse people with that. So we have, various interpretations of that. Okay. So here, the question that says, and so y'all probably thinking that, well, that's just a really bad answer over there, But I'm just trying to get a mix. Because that's what we get, a mix. So at the end of the day, we have to really evaluate. And I wish I had my grading sheet, like from the highest to the lowest, I could get to see and then show you what the D looks like. But, that right there is D, right?
Is-
The E.
E.
And so it says the statement should be admitted. A previously described hearsay is a statement made that is offered to prove the truth of its assertion. A statement may be either oral or written. Hearsay is inadmissible unless it falls under one of the exceptions. Here, although no statement was actually made by the dog intended to communicate that the light was red. Therefore, because there was a verbal assertion from a trained dog, the statement should be admissible. Does that sound logical? Because there was a verbal assertion by a trained dog, the statement should be admissible?
They were nervous. They were nervous. Test takers.
You're right, but even if they said, because there was a non-verbal assertion from a trained dog, the statement, does that make it right? That's still wrong, because there was a non-verbal assertion from a trained dog. They didn't talk about the fact that because it says the law said by a person, it says that in the statute, in the provision. So you see how when you're trying to decide, okay, 1 to 4. That's why sometimes a lot of my classes, I have like 10. A question worth 10, it'd be like 200-point exam, because you gotta think, where does this fall? Okay, 2 or 3, it's easier to, to come up with some division if you just say, okay, well, let me give 10 for each one and then go from there. To figure out where it's gonna fall, and that's why it takes so much longer. But the first 10 good essay questions for y'all. Yes, ma'am.
Okay, we're still confused about this dog. Everybody in Louisiana, is a non-verbal statement by a dog admissible or not?
No, because a statement is made by a person. Right.
Okay.
Yeah, the definition of statement is that it's by a person.
Right.
So I think the confusion is that this dog's conduct, it does come in. Right, it is asserting. Right, it's not a statement in the meaning of the hearsay rule. Okay, so it is assertive conduct, but it's gonna be admissible, but if they were a person, it wouldn't be. Right, even though they are asserting something. So they are telling you, hey, there are drugs in the trunk. They're telling you there are drugs in the trunk. Or this dog was saying, it's okay to cross. He was asserting something. But because he's not a person, it's not a statement within the meaning of the hearsay rule. Okay, that's like the first line, but I know we gloss over that stuff. But
So will we even need to say the assertive part, or could we just say the hearsay definition?
You could.
It doesn't fall into it.
I mean, you could. You really could. You don't have to talk about the fact that he is asserting something, but I think that's what the thing is intended to kind of let you sort of get confused by, because half of the class is going to say that. Even now, half the people in here today are still going to say that, since the dog is asserting something, that's hearsay, but, it's like, let me see, where we are next.
F.
Oh, yeah. Okay, Helen testified that she could not see the light, but that shortly before Peter was struck, he saw driver's headlight heading west, along with Donald, come to a stop at the intersection with Columbia. What's the issue there? What is the issue with this? This is trying to ask you what? You sleep, Tiara?
No, I'm reading the
wrong
Did she
F,
even
right?
see what
Yeah,
happened
she
at the
didn't
actual
see
light?
The actual intersection.
Yeah, where the accident occurred, could she even see it?
Is that the issue?
She couldn't
see the traffic light.
So
It was
Helen
red.
testified that she could not see the traffic light. But she says that shortly before Peter was struck walking across the street, she saw drivers headed in that way come to a stop at the intersection. So she concluded what?
Knowledge. Knowledge. Red light because
Knowledge. No. I heard it.
It had to be a red light.
Yeah. Okay, that's what she's saying. That it must have been a red light because she saw the other car stop. So she said, I didn't see it, but I saw the car stopping, so the light must have been red. So if a person objected to that being hearsay, they're trying to say what? They're asking what? Y'all missed this.
They asked him, was the light?
This is a hearsay objection.
They're asking whether their action of stopping at the light asserted that it was red.
Right, that assertive conduct. You know, okay, that gave me a good idea about flashing. What does it mean we flash our lights when you're on the highway? What do you think that means?
There's a cop.
Right, if yours are bright, they're telling you turn your bright lights off, you're lying to me. But if you just like randomly driving there saying there's a police down the road, right? So they're trying to assert something, right? They're trying to say something. So if you saw that on the hypothetical and it told you that, you know, in order to prove that the guy was down the street, she testified that the guy blinked his lights. And so that's assertive conduct, you know. Assertive conduct is hearsay if when.
That
was
not
Wait a minute.
intended to prove the truth of the matter being.
Right, exactly. It has to not only assert something, but it has to be offered to prove what it asserts. So if a person blinks their lights to say that there is a police officer down there, it's only hearsay if they're trying to offer that to prove what? That there really was a police officer down there. You know, so if the lady says that, well, you know, my lights were on in order to prove it, you know, I offered evidence or something, I don't know, but I can't, my brain is used too much with these scenarios. But it has to be, not only does it have to assert something, but it has to be offered to prove what it asserts in order to be hearsay. So we talked about that a lot when we were talking about assertive conduct. That some conduct is not assertive, but you what? Perceive a message from it.
Inadvertently.
But just because you perceive a message, just like the lady who went up there, looked in the classroom, she saw everybody looking down with their pencils, and she concluded, oh, they must be taking a final. But they were not trying to assert that message, right? So here, she is saying, I didn't see the light, but all the cars stopped. They object. Objection around hearsay. The response is going to be, well, you know, a statement can be conduct. No, it has to be assertive conduct. They have to intend to assert a message, and it has to be offered to prove what it asserted. So, and you don't look at whether or not you perceive the message. You look at whether the person intended to assert the message. So you look at it from their perspective. So here is that analysis part. This person was not intended to, those people, those cars, when they stopped, they were not intended to assert the message that the light was red when she perceived that. So since it's not a statement within the meaning of hearsay rule, it's not hearsay. Okay, so that's admissible.
Ooh, that was a dope.
That was a no.
I got 0.
No, I think you probably would have gotten between now and the next 3 weeks that we have before this time. You all notice our exam is at Tuesday, right?
Yes, Lord, thank you.
Yeah, they changed it because my other one is at, my torts is at 1. I used to have the torts at 9 and come back at 4.
Wait,
Is that the second number?
It's Tuesday. I don't know what the date is.
That's the second.
Oh.
I was saying, let's
Because all the other classes were taking it at 1 o'clock that Monday.
Yeah, no.
But I have my torts exam at 8, and I used to have my torts exam and then come back and do the evidence the same day. But I didn't ask them to change it. I mean, I forgot to even tell them when I saw it in the hallway that I noticed that he had changed it. Because students not supposed to take 2 exams during the same day. Why should I have to give 2 in the same day? Okay, so the defense may object that Helen's statement of the drivers and Donald is not admissible hearsay. Ordinarily, hearsay is not admissible. However, hearsay only affects the admissibility of statements. A statement is an oral written assertion or nonverbal conduct intended as an assertion, and assertion is a declaration of the truth. In this case, Helen is offering testimony regarding the nonverbal conduct by Donald and other drivers on the day of the event. While nonverbal conduct can amount to an assertion, it must assert something to do so. Here, the conduct she describes, i.e. driving west on Franklin, was not reasonably intended by Donald and the other drivers to declare a truth or otherwise be an assertion. Hence, the nonverbal conduct was not a statement and not barred by the hearsay rule. Do you understand it better when he says?
Yeah.
Okay.
What is he doing now?
He's a nuclear engineer who just passed the bar exam this summer.
Nuclear engineer, that's cheap.
Well, but what does that do with this though?
He brilliant.
No, but he was doing math and chemistry. We were reading in college and writing, right? He said he's gonna practice some law, but we'll see when that happens. But he just graduated in May. So, But yeah, you gotta catch these issues. Okay, AFG, what we at, H, G? I can't keep it, 1 second, right? So Eileen testifies that 2 hours after the accident, she saw Donald sitting in a sidewalk cafe. You all had this on one of your interviews. She approached Donald and said to him, "How can you sit there and enjoy yourself when just hours ago you ran that stoplight and hurt that man?" She testifies that Donald made no response to her statement.
Adoption. That's testing adoption. Not saying.
Okay, so at least we're catching the issue. You say no.
Well, I mean, that's the issue, but
All right.
I disagree with that as well.
No, I was just saying that's the issue.
Yeah, that is the issue. Okay, anybody else got a different issue? Okay, and she said, "How can you just sit there and enjoy yourself when just hours ago you ran that stoplight and hurt that man?" And Donald made no response. G.
Mm-hmm.
Did we skip H on? Or did he skip H? Oh, here's his G. His G is pretty long. The defense may object to Eileen's testimony claims that it was hearsay. Statements hearsay. It is declaring originally made out of court off the proof of the matter asserted. On the other hand, the statement may be offered for another purpose other than the proof it asserts. There, the statement is non-hearsay and not barred by the hearsay rule. Statements made under certain conditions are non-hearsay by law and not barred by the hearsay rule. By statute, a statement is non-hearsay if it is adopted admission. A statement is an adopted admission if offered against the party who adopted the statement at the current trial and the witness is available for testimony and cross-examination. Okay. Now remember this rule? Remember this rule? All admissions have to be what?
Adopted.
No, all admissions don't have to be adopted. You have to be a party, it has to be offered against the party, and it's their own statement, right? So that's that law. Statement by an adopted admission if offered against a party who adopted the statement if warning is their own, they adopted or is authorized, and the witness available for testimony and cross. A party may adopt a statement by silence if, that's that rule, Cupid, H, they heard the statement, understood the statement, what else? First-hand knowledge of the statement and would have denied if they would have, and there are no impediments. Okay, so here the statement that Donald caused the accident by running the red light was made such that Donald could hear it, and it was made right in front of him. No indication that he did not understand it, and it was made in earshot. A reasonable person could deny the statement because it imposed a civil liability on him. Donald did not deny it, rather he stood silent. There is nothing prohibiting him from denying the statement. No, there has to be no impediments to denial, as he was not heard or described as emotionally damaged. Here the court will likely find he adopted the statement. The statement is being offered against Donald, a party, by a witness who is at trial and available for cross. All of that's required, right? Because to have an admission, you gotta have those requirements for all admissions. It has to be your statement. So if it's not your personal statement, it has to have been authorized, it has to have been adopted, or it has to be, an agent or employee in course of employment. So all of this right here is what? Oh, this one don't work.
Analysis.
Analysis. All of this is analysis. That's what that is. Is that right? Okay, I don't have to write. But that's what that is. Where it went. Every element is analyzed. Has to be heard, understood, no impediments to being able to deny the statement like they sleep or half dead and all that type of thing. All of that's in here. No indication that he did not understand it as it was made in earshot. A reasonable person would deny. That's one of the requirements. It is of a nature that a reasonable person would have denied had it not been true. Okay, nothing can prevent him. And so they'll find that he adopted it. But just because you adopted, that doesn't automatically make you liable, right? It's still the statement is being offered against Donald. He's a party by a witness who is at trial. All of this, it's all of this in there. You can't just say, well, he didn't hear it. And just be done. Let's see what Bob said. Okay, it says, I would object to the statement as hearsay But it would more than likely be overruled because it was an admission. The silence of another is considered an admission, which is non-hearsay. Here, Donald did not reply to Eileen's comment, but merely responded in silence, making it inadmissible. What do you think? They caught the issue.
1 point.
I mean, we don't, there first is really no rule. And the rule that was stated was wrong, because it says, the silence of another is considered an admission, which is non-hearsay. That's not correct. That's not correct. It's not the silence of a person, it's not non-hearsay. And then the analysis was, he did not reply to the comment, but responded in silence, making it admissible. And see, this is a person who would probably get their 1 point, as we've been saying here today, for all of these questions, just for being familiar with the material, and then graduate and wonder, why am I passing the bar exam? They're not gonna pass you with this. They're not gonna pass you. I mean, this right here is a person who, not only you don't know the law, but you clearly there was no analysis, but you're familiar with the law. And you know why? I would not be surprised right now. 90% of you all will pass the exam today, if I gave it to you today. I think at least with the D, today. Because you've been sitting, at least for what we've covered, because you've been sitting here all semester long, you will be familiar enough with the facts, just like everybody in this classroom just said then, admission. But you will, over the next few weeks, get those rules down a little bit better, all of the different elements of the rule, and, put a little bit more into it that will take your grade a little higher. So what you can do after sitting in a class all semester is obviously different than what you have to do later on after you have not been sitting in a class just that week before, and you are then, having to just have it in there. All right, let's see, H. See, we got an H. Estelle saw the accident, immediately ran to Peter's side. Peter looks up at her and says, I think my back is broken. What's the issue here? I think my back. Okay, then existing physical condition, but what? What's wrong with this then existing physical condition? It is a belief, and because it's a belief, it cannot be offered to prove the thing remembered or believed, which is that his back is actually broken, but it may be offered for other purposes, in which case it's not hearsay, such as what? Such as to prove that he might be in pain or something like that. Now we know that it can be offered to prove the thing remembered or believed if it's for purposes of a will or testament, but if we're offering this, if somebody said, well, we know he was really hurt because he kept saying, I think my back is broken, would it be admissible? Is that hearsay? If it's being offered to show this guy was really hurt because he kept saying, I think my back is broken.
Yes.
Other than the hearsay, right? Okay, really just state mine on the fact, just really how he felt. That he thought that even if it's not true. But here, we're offering it, I don't know what we're offering it for, because I just started writing stuff on the end. I forgot my original plan at the top. Like, now we're not even talking about who offering this anymore, because I don't even think that, But anything, y'all get the issues, that's why I left it. So, that's what it should be. That might have been my ex-wife's ex-husband, my wife's ex-husband. Emily testifies that while waiting for the ambulance to arrive, Peter says that might have been my wife's ex-husband as he's laying in the street. What is this trying to get to? What issue is this trying to test?
Is he dying?
I couldn't figure out the issue for this one.
Motive?
Maybe under the then existing mental condition show motive or anger
Okay.
But what?
It still just says,
or it is a belief still.
I know that it's not, that it's opinion and conjecture, it's like it just he's, and we know that even if you're doing dying declarations and And even then existing mental conditions, we know that a lot of that conjecture and opinions and stuff without basis is inadmissible. So let's see what we have here for K. Is that K?
Mhm.
How did I mix all of them?
I don't know. Yeah, we didn't do I.
We skipped all those?
I and J. We skip I and J.
Okay, because I thought it was pretty clear what they were. Oh, yeah, we didn't need that one. And this one right here is just the then exist person met a trick night. Oh, that's what he's talking about. Let me see. Jay, we skipped Jay? He just got hit by a car. Was made out of court. Was that the question?
Mhm. Yeah,
Oh, he just got
That's
hit
Jay.
by a car?
On the way to the hospital.
that's J. He tells the paramedics.
Oh, okay, we had made it to Jay.
We skipped it.
Oh, okay.
And the last one we did was H.
Oh, I did skip, okay, I'm going first, I'm sorry. So what, the one that we were at, we just did I don't, no.
We
I
did-
intended to skip I don't know if we're gonna make it, but then we had on the way to, he said, oh, he just got hit by a car. Oh, I skipped all the way down to K, that's why I'm looking for the answer to the one we did. That might have been my ex-wife's husband, that's K.
Yes.
All right. Now, K is, statement is hearsay, it's out of court, however, statements, okay. One such accepts the dying declaration to fit within the acceptance statement must be made when the declarant believes he is facing imminent death and must describe the cause or circumstances surrounding what he believes this is impending death. While some opinion testimonies are liable, statements that are pure conjecture or speculation may not be admitted under the exception. To employ this exception, the declarant must be unavailable to testify at the current trial. In this case, the statement that it may have been my ex-wife that hit him, is off to prove that what it asserts that his ex-wife may have hit him. Supposed to be ex-wife
Husband, yeah.
No, my wife's ex-husband.
Mhm.
It was made on the street, not in court, hence his hearsay. Plaintiff may argue that the statement was made while Peter believed he was dying and described circumstances surrounding what he believed was killing him. However, the statement was purely speculative and conjectural because Peter had no actual knowledge about who hit him. Even if Peter were unavailable, the statement would not fit in the dying declaration exception.
So we should just pick like what it might have been closest to, and
Yeah.
then say why it wasn't.
Yeah, I mean, other than just not answering it, you know, that's the only thing.
I mean, I agree.
It's 4 points. Then we had, let me see. I think we did, okay, so any of them that might have been my ex, okay, Emily, did y'all get the L? Emily will also testify that Peter tells her that now he'll never get workers' comp because instead of finishing his deliveries for the day, he was headed to the condos on the other side of the street to see his mistress instead of completing his deliveries. This one happened. What's this?
Statement against interest.
Yes, okay, that's good. Anybody disagree or think something different? Okay, that's what I was looking for. Okay, L. A statement is hearsay if the declarant originally made it out of court, offered to prove it, One such statement is statement against interest to fit the exception. The statement must be so contrary to the declarant's pecuniary proprietary interest, goes so far to expose him to criminal civil liability, or to render invalid a claim he has against another that a reasonable person in the same position would not have said it if it were untrue. To employ the exception, the declarant must be unavailable. Here, the statement that Peter was headed across town instead of doing his job is hearsay, as it was made out of court and often proved it asserts that Peter was going to see his mistress and not doing his job. The statement rendered invalid his claim against his company because it makes him ineligible for workers' comp. It is against his pecuniary interest for the same reason. Since he's not unavailable because he is at trial, hence the statement does not fit within the statement against interest exception and is not admissible. You got that? All right. Any questions about any of these?
I have a question, but it's about more about the answer of like one of the statements.
Okay, I'll get back to it in just a second. I'll get to the answer in just a moment. Did you have a question about this?
Can we just look at the good answer for number 3? Because I wasn't sure how to
Number 3.
set that one
Number 3 down at the bottom, poll number 3. So you got an answer, you were quiet when I asked for answers.
up. No, I issues got it. I didn't.
Okay, what was number 3 about?
Nita University.
Oh, okay. So what did y'all think that issue was? Did you discriminate? I said, I talk about direct examination. The very first question, he gets up, this actually happened in one of my trial ed classes that I was taking. Dean Williams, did you discriminate against the plaintiff? What would be your objection?
That's what you got.
Leading question.
I don't even know what he wrote. I didn't look at anything past like his first 1 or 2 answers. So for like this really whole exam, I don't really know. I obviously was a Cali, but I don't know if he got them all right. But what would you say?
Did you object to leaving?
Did you discriminate against the plaintiff? So you called, Your Honor, I called John Williams. Okay, John, yeah, I promise to test you. Okay, John, did you discriminate against the plaintiff?
Just
Isn't that
laying the.
that's
That is-
what's
that
left
is
to the
like
trier of
perception.
fact to decide?
Yeah, that
Not-
is. That's good, that's part of it, that's good.
Okay, that's what.
What else? That's a good
Lay
start.
out the foundation.
Okay, foundation to get there, and the discrimination is what the case about, okay? That is the ultimate decision that they have to make in this case. And so if he's giving some opinion testimony, then we know we want you, it has to also be what, helpful, right? Opinion, that's part of the rule, right? It has to be reasonably based on perceptions and helpful to a clear understanding of the law. And the law perceives, or at least it has interpreted that if a statement gives you the final answer that you dare to decide, like discrimination, that is not helpful to the jury because you gave them the answer. It's supposed to help them, not give them the whole thing. Like y'all want it, y'all want the whole thing. I'm supposed to help you, but not just give you the answer, you know. So the discrimination is giving you the answer. All right, so it's kind of what both of you all are saying. No, you're supposed to give them foundation, whatever you're gonna have them to testify to, but not. So let's see what he wrote. Because I was looking for something in that area. He says he would object to leading, so that would not be correct. Leading questions should not be asked on direct. As exceptions, leading questions may be asked on direct if the witness is hostile, identifies adverse parties, or questions are needed to set up testimony. Now, the thing about leading questions is asked on direct by the school's attorneys to dean. Now, some people will say that leading is typically, you can say leading if it's a series of the questions. So if you ask the person, say for instance, you had a woman walking, you know, she says, oh, this guy was attacking me, was in self-defense. But it's a bunch of people in the room. So if you say, when you walked into the room, did you call your mom? No. Oh, did you tell the teacher? No. Did you leave out of the room? No. Did you move out? No, I didn't do any of those things. So a series of the questions are perceived as, okay, you're leading the witness because you're trying to drive them to that one. But typically one, you're not going to get a sustained.
So it's no way that one question will be considered a leading question?
Yes, because a leading question suggests the answer. So if I said, you know, you were driving your car yesterday, yes, and you were headed to school when I saw you, yes. When you got there, you parked in the parking lot behind the school, you're giving the answer. So yes, one question can be a leading question, but a did question, did you call your mother, is not a leading question. Because you say no, I didn't call my mom. But if it's a did question, it's said to have the effect of a leading question if it's a series of questions. But a leading question is one question.
So it'd be
You know, you were, and you saw him when you walked in the house. Yes, because I'm telling you the answer. That's one question. Yes, that's a leading question. Okay, hope I didn't confuse you with the did thing.
I'm not speaking to everybody else, but I stay confused on leading questions.
Okay.
And I don't know if it's because I've been to court with the attorneys I work for, and a lot, you know, I'll see like Tony Clayton. He'd be like, and you did this,
He
right?
says what he wants to say.
Yeah, and he got yelled at too by the judge.
I wish I had gone to that trial.
You should wish, because he got yelled at 3 times by Judge Jackson.
Good.
It was good. And he said, okay, and you did this, right? And you did this,
Now
right?
that's cross.
Yes.
Well, yeah, you can do it on cross.
But then what about on
On
direct?
direct, that's what we doing this.
Okay,
Yeah,
so,
you're not supposed to do it on direct.
so the attorneys I work for obviously objected,
Right,
but he would just, and so, you know, he would keep going, but do the same
right.
thing, it seemed like, so I'm just confused.
But, I mean, he's not supposed to be doing it.
Okay.
You know, but the thing about it is, sometimes you find that the more experienced attorneys are sometimes, and especially if they have a reputation in a particular community, they would just let them do things. Then let them do things they're not supposed to be doing. If you did it, she would say, now look, young lady, you know that on direct examination, you're only supposed to be asking open-ended questions, okay? You know the difference? Okay, so, try to keep it that way, all right? All right. And so that you go ahead, but it's kind of like, oh, I've been doing this 30 years, everybody knows my name, I'm gonna do what I wanna do. You know, and so that's kind of, but you do have to really, really, really keep pressing it and keep making those objections, because at the end of the day, if you got the law on your side, you can go back and say, hey, you know, it's a question that suggests the answer. Now, most of the time, people are gonna make the objection whenever you get a yes or no question, you know. So did you go, but when you have alternative, we talk about this more next semester, you know, we give them alternatives. So when you made it to the house, did you go inside or did you stay in your car? If you give an alternative, that's okay. You know, and it's not just because, you know, and are you a student? It's a yes or no question, but it's not leading. But it's when you do suggest the answer. So you're a student there, yes, and you're in your second year, yes. So most of the time, it's the yes or no is a good indicator that it is, but not all yes or no.
But it's those were kind of foundational.
And right, and so when he's doing that, yeah, he's definitely leading, but it speeds the testimony up. You know, when you just say it, you know, and then you went inside when you made it there, right? Yeah, that's leading.
So you can just say,
You're supposed to say when you
what'd
what
you do? Okay.
You know, what did you do? I went inside. Was anybody there inside when you made it inside? Was anyone in the house?
Okay.
Yes. Who was there? But you don't say, when you got there, you went inside, right? And your mother was in the living room, wasn't she? And you asked her where she was going. She told you blah, blah, blah. All of that's leading, all right? So, any questions about this exam? Any particular questions? Okay, most of these you've seen before. You've seen practically everything on here. Most of the exams that most of the questions you're gonna get, they are variation on what you have. And, you know, but a lot of new stuff.
As far as the breakdown of the test, I'm not sure if you've told us already, or if you do tell us how many multiple choice, how many essay.
I'm really thinking that it might be 40 to 50 multiple choice. I'm giving you, I know 10 solid essays off the top first, you know, because I need you to write, and I need you to write for real. You know, and that's why it's gonna be on the front and not the back. Because I found if I put it on the back, it's kind of like the end. So it's like, oh, okay, this is meant to be a short answer. I don't mean for an answer to ever be a short or a long answer, like neither one. I just need it to be whatever it takes, you know, to answer the question, you know, based on that. So it may be 40, maybe 50, but I always do about that, but I definitely keep my essay. Gotta have some essay on there to really press that.
At least 10 is what you said.
Yeah. So at least 10, yeah, I think it's gonna be 10, and then maybe just a little bit of listening. And you got those 2 charts that we're gonna be working on next. Okay, you had a question about this one we just turned in, or the one coming up?
Yeah, the one you turned in.
Okay.
It was the part where the Zimmerman statement, and he was like, Trayvon told the girl he looked like a creepy ass creeper. And the issue stuff was like, presence is impression, describing.
Right.
But in my opinion, that's not actually describing.
What it
Like,
really
it's
was?
more of like an opinion of what you think somebody is. And so I was wondering, like, for presence and impression, it has to be like, he's white, he's tall, or it's a red car, or something like that. It can't be just like, oh, that person looks scary, or something like that.
But that is what how you're perceiving
I
them.
mean, really,
It's your impression.
Yeah.
Right. I mean, I really feel like that is, it's a good question, I think, you know, because people can characterize things in a way that you may say you're not really describing, but I think in that person's mind, I am describing what I am seeing in the way I describe and the way the person he was talking to knew. If you looked at the actual transcript, you know, he was using all types of racial slurs and stuff, and I changed a little bit. But she knew what, you know, what she felt that they were understanding each other. In fact, he would even say, "What did that mean to you?"
Okay.
You know, and so, you know, it was kind of like, you know.
And I just want to see.
Yeah, but I think it's an interesting question if a person just said, if they call themselves described, because sometimes it could just be, you know, the guy's breaking in cars and he's really not breaking in cars. You know, or I think this guy's trying to steal something, he may not really be trying, it may just be your opinion. But I think as far as the exception goes, I haven't seen anything on that really places limitations on your description based on whether it's opinion or conjecture. Okay, so I got some other stuff we can do. What do y'all want to do?
Yes, other stuff, yes.
Okay,
just-
so do we want to do some review
Yes,
of some material or what?
yes.
Some part 3 material review stuff?
Well, okay, it was just a suggestion. Well, hold up, I don't know how to phrase it. Okay. I'm just about to show how dumb I am. It's okay. So, whenever you're answering questions, sometimes, whenever I'm answering questions, I don't know when to talk about, like, clearly he didn't talk about any of this stuff I thought you needed to talk about, like, relevancy sometimes. So, because even though we've determined that it falls into an exception,
Right.
hearsay, is it, you know, is it relevant? You know,
Right.
do we still do all that?
No, usually I ask you, for the most part, I can pretty much guarantee you one issue and, for most of the questions.
Okay.
And if I want more, I usually say more. Like, I will say, they object. I think I almost always give you the objection. And I say, you know, John will object that statement is hearsay.
Yeah.
You know, or John says it's not relevant. Every now and then I may ask you, but you have a lot of multiple choice questions. And the multiple choice questions, we're working very hard to make sure that the questions that we give you are going to be solid
Okay,
in
good.
terms of, yeah.
Yeah.
'Cause, I mean, so really and truly, I mean, we're gonna, I told you we're gonna have a lot of the same, but we're trying to see how this works. So this is gonna be interesting for all of us. But at least somebody else would have looked at my questions and my answers. You know, I mean, usually, you know, I find out sometimes, like, maybe 2 years later, oh, nobody never mentioned that before, you're right. Okay, well, too bad, now they're gone. You know, but at least somebody else is looking at it, you know, and we're looking at each other's. So we're able to have that check and balances there, you know. Do you all have the issues, we just kind of started on, we did forfeiture by wrongdoing, right? Let's take a look at a problem on forfeiture by wrongdoing, which is what we just did. That's on your, that's on the instruments coming
It's on
up,
the-
isn't it? Okay, so let's take a look at that real quick.
President, can I ask a question?
Yes.
It's not on this. So you just said y'all trying to like make the exams together?
Yeah, I told y'all that.
And who the professor?
Just John.
Oh, okay, okay.
Oh, okay.
I was like, wait, some people don't teach us anything.
I know. And I'm interested to see what he thinks of my questions. Because I think some of them he's gonna say, oh, you know, I don't know what he's gonna say. So, wait a minute, it's on my thumbs, all right. Let me get it real quick. I'll be right back, my fault.
Alright.
Oh, I know, they can leave.
Okay, is that in here somewhere? That's the one we missed.
Yeah, because even if you did it's irrelevant, and then what are your answers and else
So what we
No, he's a judge.
you know, I know
See, having
she'll
my
say,
office there spoils me, because see, I've already been back to my office 2 or 3 times, and I leave everything when I know I can go back. So,
What,
I wish I had all the classes right here.
oh, shit, yeah, that's it.
Okay, so let's look at a couple of these issues, because I think this is a good opportunity for us to talk about
It's in here.
stuff.
It might be. Oh.
That's part 3. All right.
later, what do you say?
and that is the interim corporate.
Former testimony.
All right, so. Well, it's not really on here. Is there, have y'all looked at these?
Yes.
Ma'am.
I was saying I did, but are we allowed to ask you a question out of it now, or?
You may.
For, number three, what do you mean in, for C? I didn't understand the question.
Okay, so we talked about Crawford, right? And let me skip down to that. You know you're supposed to went back and read Crawford, and all of this is in there. We're gonna talk about it further when we get there. But Crawford said what? And this is important because it is like 2 or 3, at least about 4 questions on your final that's gonna be on Crawford. So, and I told you that when all of this hearsay stuff, we've been talking about prior to Crawford. Once the court found that it fell into an objection, you know there's a constitutional right to confront and cross-examine witnesses. And prior to Crawford, once you made an objection that the person was unavailable, that it was hearsay, once they found that there was an exception, it was like, well, forget about your constitutional rights. It was, the statement is admissible. But after Crawford, it said that no, that's separate. You still have your constitutional right to confront and cross-examine witnesses, okay? And so, even if you find that there is an exception. So Crawford basically gave us a standard. Do you remember what that standard is? And I said, under what circumstances would you make an objection to the admissibility of the Sixth Amendment Confrontation Clause, which of course we know what it is. And Crawford precludes unconfronted testimony from being used against the accused. Both must be present to exclude testimony. It must be testimonial, no opportunity for cross on the prior statement. And that's no opportunity past or present. So basically, Crawford says that if a witness is unavailable currently, if they're unavailable to testify now, then there must have been a past opportunity to cross. If it's testimonial, 3 requirements, it has to be testimonial, unavailable, and a prior opportunity for cross-examination. So those are your main 3 requirements for Crawford. They are unavailable. There must be prior opportunity for cross-examination, and the statement must be testimonial. What's testimonial? We briefly talked about what constitutes testimony.
Affidavit.
Okay, affidavits, what else?
Depositions.
Depositions, former hearings, like at a trial. So we're looking at like what's real testimony. We know a testimony is if you testify at a trial, like a preliminary exam, right? We know that's testimony. But testimony is any time you make a statement that is in reasonable anticipation that it will be used eventually at a trial. So if the police call you in for a formal statement, then that's going to be something that you know that when you sit down, you're like, let me get it right. Because you know in your mind, this is probably going to be used for the trial eventually. So that's testimony. That type of statement is something that they have a right to confront and cross-examine you on. So if you make that formal statement to the police and now you die before the trial comes and they want to use that statement, then they're going to say not only is it hearsay because it's an out-of-court statement being offered to prove the truth of the matter asserted, but it violates the Sixth Amendment Confrontation Clause because I can't cross-examine you on it. So if it's testimony and the person is unavailable now, the only way you can admit it under Crawford is if there was a prior opportunity for cross-examination. So if it was, if the statement was made in the preliminary examination, they had the prior opportunity to cross-examine, right? Your analysis is completely separate. You know you got some analysis similar to that for former testimony. But that's separate. Deal with your requirements for hearsay, but then you gotta deal with your separate Crawford requirements. So the person has to be, so, you know, we'll take a look at it closer. And I say here, remember, we're evaluating the admissibility of the prior statement, not anything present witness may be testifying to. So you're looking at the prior statement. Just because there is a hearsay exception doesn't mean the statement will come in. If there's also a Sixth Amendment issue, must clear it through the hearsay and the confrontation clause. So we know that 3 requirements: the witness is unavailable, must be testimony, prior opportunity for cross. We know what unavailable is because we've already been dealing with that also for the last 2 weeks. Prior opportunity for cross-examination. So if it was not cross, so we know it wasn't cross if you're at home, if you make it to the police. It's also depositions, affidavits, all that formal stuff. There's no ongoing emergency. So if you call now, and these are your cases, we looked at them briefly, we're going to talk about it a little bit more Monday. But if you are on the phone and you call 911 and the police got there and they said what? Was it Giles? When she called 911. Oh, he's trying to get me. The police came and they said that it was an ongoing emergency. She wasn't making that statement for the purpose of like testimony. So do you have a Crawford? Crawford is not implicated there. You see how those issues in the problem? So, and then we have, so if that 911 call comes to trial and the person says, I'm objecting that the 911 call is hearsay, and I'm objecting that it violates my Sixth Amendment confrontation clause if it's in the criminal trial. So in order for it to come in under Crawford, what has to be there? It's testimony. It's a testimonial. We just went through that analysis. When she's on the phone, 911 call saying he's trying to come break in the house, it's not testimony. So does it violate Crawford? No, it's clear through Crawford. Now let's say the police officer says, okay, well, we can't find him. You want to sit down and talk a little bit, more about it so we get more details about what happened? Yeah, that's what I want to do. All right, so tell me all about it. Now, what do you think about that? Is that testimony?
Yeah.
No.
What? Is that testimony?
Well, yeah.
When she sits down to make the formal statement?
Yeah, that is a formal
Yeah, that's
statement.
testimony. Okay, don't let one wrong person now drag you down. Okay? Just messing with you. But yeah, it is testimony. It's a formal statement. Now, when he says, let's sit down and let's talk about this, I need to get all the details. You already know this is not the end of this. This is the beginning. Let me put it down good. Don't forget to write my other cousin. She saw it too. Because they know that this is going to be used. Okay, so now if that goes to trial against him in the criminal case, we know that this defendant he has a right to cross-examine you. If she's gone somewhere now and they want to use that formal statement, you got a hearsay issue and you have a Sixth Amendment confrontation clause issue because that's testimony and the person is unavailable, so it's only going to be admissible under Crawford if what?
They had a prior opportunity.
They had a prior opportunity to cross-examine the witness. So this chart right here is in your book. So you have, is the statement testimonial? If the statement is testimonial, it's automatically no, right? It's admissible because you have no Crawford protection. So if it's like a random 911 call or excited utterance, it's not testimonial. So those statements are admissible. But if it is the witness currently available to cross? If it is, why is it admissible then? Because you can cross it now, right? Okay, exactly. You had no prior, you have to have either a prior or current opportunity to cross. If he available, cross it today. But if he's not, was there a prior opportunity to cross? If yes, then what? It's admissible. If it's no, then it's inadmissible under Crawford.
So when they say prior, that's like, say.
Whenever the statement was made.
Whatever.
Yeah, whenever the statement was made, was there a prior opportunity to cross-examine him? Well, not made, but on the statement, a prior opportunity to cross-examine him on statement. Keep in mind, grand jury proceedings, no defendant isn't there. Defendant is not at grand jury proceedings.
So that would be if you put that in the hypo and say it was a grand jury proceeding.
If it happened, if he testified at grand jury, was there a prior opportunity for cross? No. Defendant isn't there. He has no confrontation rights at a grand jury proceeding. He's at home hoping and praying they don't indict him. Yeah, he doesn't even know, I mean, he knows about it, that they convened, but, you don't get to question them. They don't even, this is private. They don't even see it. They don't even get a transcript. A lot of things that happen, they just are complete, and I say this because I've questioned witness about things I didn't say it was in the grand jury proceeding, but I learned about it from reading the grand jury transcript, and they're like, wait a minute, she didn't say that with any other witnesses. Like, oh, she did say it with the grand jury. But anyway, so in a situation like this, when I say, would your answer change if he had no accident? And the reason why, because I said up here, in the accident, he fell on his head and died. So if he had no accident, that's just saying what? He ain't dead. Okay, and so but the prosecution insists on using the prior testimony. That's just trying to let you know now. You available for cross-examination, okay? And so, so that's kind of what that's getting to. But you have, I think, two statements here. You're dealing some with 911 calls, you're dealing something that may be testimonial or not. And then here, let me see. And so, of course, this grand jury. So down here, it asks, would your answer change if it was a preliminary exam? What's the main difference between grand jury and preliminary exam as it relates to property?
But the preliminary
Right, you can examine it, you can examine a preliminary exam, but you don't have a cross-examination in a grand jury. So, it typically would make a big difference as far as your questions are concerned, because that's the whole purpose of property, to give a person a prior opportunity for cross-examination. So if a person testifies in a preliminary exam, and then they come back and you want to use the preliminary examination statement, if they are unavailable, and we know if you testify, that's testimonial. If you had a prior opportunity for cross-examination at the preliminary exam, then it does not violate property to use that statement. Okay, and then let me see. The other thing, and then you got the forfeiture rule that you got to make sure you know that. And like I said, I always test those issues, but you have to be able to identify. It's a real simple concept of just identifying if it's testimonial or not. If it's not, you know it comes in, but if it does, and the guy's unavailable, you can't cross him today, you had to have had a prior opportunity for cross-examination before it come in. So that's what these issues get to, because you have a guy like here. The week before the murder, Omar had called 911 one afternoon immediately after completing Bowen's lawn and desperately reported that Bowen, well, I got one that's not on here. Let me give you that one. Let me see. One that should be one in here about the lady. I think it's the one that we'll be talking about it though. This is kind of the same, based on the same. I mean, like when you see the problems, you know that they're going to be pretty much the same situation, because I mean, it's just kind of changing the facts up a little bit. But oh yeah, that's your list of issues. Let me see. I mean, yeah, this is your list of what's testimony, affidavit, depositions. Make sure you know that so you'll identify those issues. Formal statements of police, custodial examinations, no ongoing emergency. So they call 911. It's no ongoing. If it's an ongoing emergency, like come and get him, he's trying to get in, or come to the house to get him. That's we have it's testimony. Okay. Mary involved in altercation with her husband. She ran into the bathroom and called 911. Is that testimonial? Okay, no. When they arrived, Mary's husband had left the house. She went outside to talk to the police about what had happened. She pointed down the street and said he ran that way. The officer walked down the street and didn't see husband. He returned to Mary's house and walked and asked her to write a sworn statement as to what happened. They went inside into the kitchen and prepared the statement. Mary signed it and gave it to the police. This is 5 statements. Just as Mary was finishing up the statement, she heard someone fiddling the doorknob. She began crying and screaming, a lot of typos, to the officer, please don't let him get in here. Please don't leave me with that monster. Please, I'm scared to death. And the next day, another officer from the DV unit, the domestic violence unit, called Mary into the station for a detailed statement, and Mary went and gave an hour-long interview. So you got 5 statements. She asserts her spousal testimonial privilege. at the husband's trial and refuses to testify. The prosecution would like to offer all 5 of those statements against Mary, against her husband. Husband objects on Sixth Amendment confrontation grounds. Which of any of the statements will not be excluded on confrontation grounds? Why or why not? We got the 911 call that she initially made, the statement she made in the front yard to the police, the affidavit of the incident, her statement in the kitchen when the husband returned, and the statement made to the DV unit. What about the 911 call? It's not gonna be excluded on the proffer because, okay, it's not testimony, okay, so there's no right to cross-examination when it's not testimony. What about the statement made in the front yard? That statement says, when they arrived, Mary's husband had left the house. She went outside to talk to the police about what happened, and she said he ran that way. The officer walked down the street and didn't see husband, okay? So he went behind, down there looking for him. So is that statement testimonial? He ran that way. Why not? Okay, it's an ongoing emergency, okay? So she's not saying it to so-called prepare that will ultimately be used at testimony, to ultimately be used at trial. It's an ongoing emergency that they're trying to deal with. He's trying to get the guy now from her. I mean, to keep him, to save her. After he went down the street and didn't see her, that's when she came back to do the sworn statement in the kitchen, signed and gave to the officer. So it's, okay, so this is testimony. So will it be excluded on the property? What would be required to admit it?
It has to be testimony, which it is. And she has to be unavailable, which she is because she asserted her her privileges. I don't think she had a prior opportunity.
No, because this is it right here. There was no prior opportunity to cross-examine her on this affidavit, so therefore what?
Therefore,
it's gonna be invisible on the property. Now, what about when he came back knocking on the door, she said, please don't let that monster in here? And then, is that statement gonna be excluded on the confrontation grounds? No, why?
would that be the ongoing investigation?
Okay, so now we're dealing with an emergency situation when she's saying, don't let him in here, I'm scared to death. It's an emergency, it's come back. It's back again because he's trying to get her. So again, this is not testimonial, so. Now what about the next ma'am?
Inadmissible under proffer doesn't mean it could be inadmissible under some, like, admissible under something else.
Right, exactly. Even hearsay. You know, most of the time, you know, you would say it's hearsay and it should be excluded under proffer. And you have to find an exception and you have to clear it through proffer. Now, for my exam purposes, I usually say he objects to Sixth Amendment ground, no hearsay objections were raised. So I usually try not to deal with them both, but if I do, I tell you what who are, you know, or I don't say and I say what would the objections be, because they can be. And also everything else applies. You know, it does still have to be relevant in the case, obviously, and all the other stuff still has to be there for it to come in. With this one, the statement she made to the domestic violence unit for the detailed statement, the hour-long interview that they want to use at the trial. I mean, clearly that's testimony, right? It's a formal statement made to the police. So, now, would your answer change if Mary agreed to come to court and testify truthfully at the trial about all of the events of the day? Yes. Why? He can cross-examine now. Okay, so he can cross-examine her now on the prior statement. So as far as Crawford is concerned, you can admit the prior statement. Now, the prior statement may still be excluded under hearsay, but it won't be excluded under Crawford if you can call the person if you want to and testify. Mary informed her husband that she would be in court for the trial. He begged her not to testify against him. He insisted that she would. She insisted that she would do something, testify against him. Husband told her if she testified in court, an old cellmate of his would kill her for him. Husband then had the cellmate drive to her house, get out of the car with a 6-inch machete, and show it to her. Mary immediately packed the bag, left town, refused to answer any calls from the prosecution. Mary did not show up for trial, and they don't know where she is. The prosecution would like to use all of Mary's statements. They object on confrontation grounds.
Is she not unavailable?
What ruling?
Unwilling.
The person is being made.
So the question though here is,
If they unavailable.
The question here is now, they wanna use they wanna use those statements that Mary made, but now Mary has ran off because of what?
Because of his wrongdoing.
Okay, because of his wrongdoing. So
To
how does
prevent
that
her
affect
from
the case?
testifying.
What was that?
I was saying to prevent her from testifying.
Right,
That's effective.
for the purpose of preventing her from testifying. This brings in the forfeiture by wrongdoing. So what do we know forfeiture by wrongdoing? If you act for the purpose of preventing a person from testifying, can you now claim the Sixth Amendment confrontation grounds? No. Okay, so he can't claim that he forfeited his right to confront her when he procured her from not being there. And so also we have the exception. We have the forfeiture by wrongdoing exception to the hearsay rule as well. So not only does the statement come in on the 8047 because it on the hearsay, but also as far as the Sixth Amendment confrontation clause is concerned, if the person procures or otherwise causes the person to be unavailable for the trial, then that person forfeits their right to confront the witness. But we know that at a regular murder trial, or if you just, whatever the case may be. Now keep in mind that in my facts, obviously, I told you that he sent his guy over there. In real life, the woman just left town. And so now, which is what happened with Drew Peterson, it's like, I don't know where she at. So what happens then?
How would we be able to, I mean, would she be unavailable still? I don't think she would be.
She is unavailable, but in order for us to prove forfeiture by wrongdoing, in order for us to invoke the forfeiture by wrongdoing, we have to do what?
We have to prove that the reason she left town was because he was trying to prevent her.
Exactly.
from testifying.
So you just do that the best way you can.
Oh.
I mean, you just have to do it the best way you can. Because he's obviously not going to say, yeah, I got to admit, I did send my dude over there with a machete. You know, you have to prove it however you can prove it. You know, and that's why that case was tied up so long with the Drew Peterson case. I mean, he clearly was adamantly denied. If they had proof that he had put the woman in the bucket, I just feel like that was on the movie, the Lifetime movie that, you remember the big canister? Like the old, yeah, the barrel, yeah, that big barrel thing, that they saw him moving a barrel once, and they said they know that her body was in that thing. You know, she just came up missing, whatever, she was really the fourth wife, but the wife whose statements that they wanted to use. So, but in any event, but anyhow, he's just like, I didn't have anything to do with her gone. I mean, and even if I did, it wasn't going to necessarily be said because I was trying to keep you from testifying at the trial, right? Okay. There is no exception to the confrontation clause just because the defendant killed or otherwise caused the declarant to be unavailable. He had to do it for the purpose of preventing the person from testifying, and they only forfeit their right to confrontation if they procure or otherwise acquiesce in the person. So that's pretty much the same. Any questions about any other provisions?
We got a question.
I had a question. What's that?
Okay, it was under the Trayvon Martin thing too.
Yeah.
And it was 9A. I think this.
Yeah.
I don't remember the statement. But I think I think it was the one where you said, well, the person asked, well, what does that mean to you? And whatever, what did you interpret that to mean? And then she says, that means he was going home. So I don't know, I was trying to figure out what
Okay, what's because I think on my question to you was, what would your response be to a hearsay objection? And so there are other objections that might come into that question outside of hearsay. But if you had to respond, if they literally said objection hearsay, what would you say to that? Do we have an assertion that's being offered to prove what it asserts? Why not?
Well, because she's just saying that I thought that based on that, I thought he was saying he's going home. Like that, I'm not asserting.
Okay, so, but we determine whether or not something is hearsay by what? There has to be an assertion, some out-of-court statement, which in this assertion that's being offered to prove what it asserts. So, first and foremost, you have to use the law, right? So, if a person say, what did you think that meant? What should your answer entail?
That's not asserting.
it's not asserting anything, because why? It's a question. For one, a question is never hearsay, because it's not asserting anything. You know, there may be some situations you can work to say, well, I think by that question you were trying to assert something, there may be. But typically we're saying commands and questions are not assertions. What are y'all having for lunch? You know, what am I trying to assert? You know,
Why I was trying to, like,
if now in real life, not to cut you off, but if I just saw that, if it was just at a regular trial, I would probably begin objecting with relevancy. You know, because I would say, why do we care what she thought? Let the jury think what they thought. They just heard the testimony. She said what he said, and let the jury conclude what they think she meant by it. So we don't care what you think. It's like, oh, do you think that's right? Or we talked about that a little bit when we talked about relevancy. You know, do you think it's that people should go to work intoxicated? Like, you're not on trial. This person isn't here. We don't care what she thinks. You know, so that it's not even relevant to me. But sometimes you get away with that in order to just take it to that next level, that next step in the testimony. But as far as the hearsay objection, remember to use the hearsay rule. You got an assertion, it's asserting something, and then a truth, and then it's being offered to prove the truth of what it was asserting. So, and what did he said, I think I'm gonna go back to my mom's house or whatever. And what did you take that to mean? There's no assertion in that at all.
see,
So
I
it's
didn't
not
think
hearsay.
I didn't think it was hearsay. I didn't think it was hearsay. So then I started trying to look at like the non-hearsay things. And so in my mind, I was struggling with this, and I thought it was wrong, but I was like, let me just try it anyway. The state of notice or knowledge to the hearer receiver, because I felt like it was basically trying to say that she understood that when he made that statement that he's going home. So maybe that could be admitted later to prove that maybe he was going home. He wasn't going to attack.
And I would accept that response. But no, but keep in mind, if a statement is being offered on the state of mind of the hearer or state of mind of the declarant, which is one of the state of mind, really not. Sometimes I use them interchangeably.
Okay.
But then it has to be a relevant state of mind.
Right.
So keep in mind that if you say, well, it was notice of knowledge to her, now it's knowledge, but that's not relevant. It's not relevant in that case as to what her state of mind was, as to what he was doing. So it kind of goes back to the same point I was trying to make before. Unless you can find something, because if you say, well, then she went and called the police, and that was important because that's how the police got there. And then we're like, well, what did you take it to mean? Oh, when you heard him screaming, or you heard him say this, well, I thought he was in trouble. And as a result of that, what did you do? Well, I went and called the police. So now her state of mind is relevant to explain her actions that she took. But in that case, I wanted you to get to the question part and to be able to identify that it was not an assertion.
I missed that.
Okay. But I think sometimes we kind of forget, like in that, because even when we were talking about it in my office the other day, I asked somebody, what was the question? Because I didn't remember if I said, make any objection, or if I said, what would your response be to a hearsay objection?
It's hearsay.
And so that's why it makes a difference. So I think sometimes you get down in, like with the Peter and Bob, the last question was, he always stops at red lights. And then I expect y'all to talk about having routine practice, but all the way at the top, my original question was hearsay to all of the things, but we always forget by the time we get to the Bible. That was the habit. Did y'all get that one?
That's what I thought when I was
Habit. Yeah, he always stops at red lights. So we haven't made it today yet. I've been just writing habit problems yesterday. I'm sorry.
I thought it was reputation or something.
Yeah, have a routine practice.
All right, well, I mean, clearly I'm not the only one that messed this one up. But what I was talking about earlier was like, I don't know when to talk about this and this, although I know you're specific to the.
Don't worry.
Well, so I put. I said it wasn't hearsay for specific.
What was this for?
The same one, 9A.
For that question?
Yes, for 9A. But I talked about that, she's like a lay witness and it's okay. She can give her opinion and it was rationally based on her senses
What sense?
that she heard him. But I was just making the art because you were saying, what would you? Yes, I was digging real hard. But I did say it wasn't hearsay, but I didn't get, any of the.
It should have been there. Yeah. And y'all were on the right track that it wasn't.
Okay.
I mean, that it wasn't, and there wasn't anything really good for it, But, for that one right there, with the question of, what exactly the question was, whether you take that to mean,
Yeah.
No one would even make it back as a hearsay.
Well,
objection.
yeah.
Yeah, you know.
Just that she was
But
inferring
it was
like
the
it went
question,
home.
yeah, she
No.
inferred. But don't get that confused with that lay witness opinion, because lay witness is really the general rule that they really can't.
Yeah,
You know, you're not an expert, you're not supposed to be giving opinions.
yeah.
But it's kind of like, but the exception though is you
I was just
can-
making the argument, but then,
On
eventually
Now, you
concluded.
can hear things, and based on what you hear, you can make a draw, you may hear a sound, oh, that's a baby crying. And you testify and lay the foundation as to what the perception was. And then you can testify to what your opinion was. But yeah, I kind of wasn't trying to get to that, but it was something I wanted to say when you started talking though. I didn't want to cut you off.
Oh, sorry.
And, but no.
Probably
What did you
more
start
than-
with?
I don't know what
You
I'm
were saying
doing
something
ever.
about all the different, all that it's a lot of different issues that may come in.
I said competent, I was talking about, I just don't know when to
I
use
thought it was
things.
something I needed to say.
Mm.
It was something.
Anything you say is probably what we need to hear,
No,
because
it's needed. I
Some
think.
about
She'll say if
403.
it's a hearsay objection, or if it's a relevant.
Oh, yeah, that you're, that you'll specify what kind of objection it is.
I do for the most part. I don't remember what it was.
Is everyone leaving?
I don't know, but let me tell you all, I have this big chart. I talked to a couple of you all about it. I don't have it in here. But it has like the arrows and all that kind of stuff. And I said I was gonna make copies of it because a couple of people asked me for it. And so when I went to Kinko's, they have that big huge, because you know how some people learn like that, they want to see the arrows and all that, excuse me, that type of thing. But the guy was like, well, you can do it yourself, but this is copyright. We can't photocopy it for you. And so for us to do it, like, we gotta have you sign a copyright waiver form. But you can do it yourself over there on that one, but that one is black and white, and it's all color coordinated and all that kind of stuff. So, some people are like, well, I can really learn off that because it really helps with all the arrows and the different colors. But if you photocopy it on the black and white printer, you're probably not going to be able to see what's going on because all of the colors are dark, and they probably did that intentionally, so that you couldn't do that because it.
Where'd you get it?
One of mine, they send me all these supplements, different, like one day when I get my book done and send it to people all over, they're gonna be like, oh, this is really great passage on how this is explained, so let me give it to my class. So that's kind of where it was in the back of the book, but it was a big map that you unfold.
You can't take like a picture of it and email it?
It's the size of this table, like literally. It's for you to hang on your wall and study. And it just so happened, and I kind of thought it was Professor Wilson's son. I had seen him only one time at this school, and I was like, I thought that was you, because I had on an assistant DA shirt, and he asked me if I was assistant DA. I was like, no, I used to work up there, but I work at the law center. My mama works up there. I immediately knew who it was. It's really, really tall. But anyway, that was beside the point. But anyhow, he was like, we don't even have a printer. We don't have one that big at this location. He's at the Seagan location. So I went over there and I was trying to get it done because I promised a couple of you I would do it, and bring it to class and show everybody, let you know if you wanted one, how much it would cost to print your own. Because it's like $10 to photocopy everything. So I will let you know if you want one, you can pay for it. But anyway, I just want to say that that if you want to print one, if you want to photocopy it, I don't care if somebody got a big enough photocopier to copy it for you. You can come and get it and have it copied. But I know a few people said that it would really help them because they were going to try to do their own. All right. But that wasn't what I was thinking about when you said your questions.
Sorry. You should just interrupt me next time.
Okay, and sometimes I have, because really I'm getting old, I got to do that now. Sometimes I just have to say I'm sorry. You're young. Okay, any more questions? Okay.
I don't know.
Okay, now, like I said, Wednesday, I'm giving you, I put part 4 up.